Memo of calculation. What memo of calculation? Huh? All right, we'll take it up. Learn it. Counting for the parties have filed the salary certificate today. The same is taken on record list in the next. Memo has been filed seeking leave of taken on record. Rectification of office objection. Who has served? The government advocate states that he has supplied a copy of IA 1 of 21. Who has filed? Which respondent? One has served a copy. It is stated served the other respondents with objections therefore ignored. Let the appeal be listed for orders on admission. Admission in the next week. Next week. Huh? Appeal is admitted for hearing. Admitted for hearing. Appeal already. File an application. Please file. You take it. Weeks prevented.
Non-deposit. Fifth matter.
Wishing of PF next non-depositing of
2019 or till now.
weeks prevented. 2 weeks prevented. Weeks prevented. 2 weeks prevented. See, Mr.
For the
What?
appellant.
And they have proved the memo and not present. You tell the lawyers, don't give them one memo. 2 weeks prevented.
Appear for the appellant, a week's time may be granted, your lordships.
Weeks prevented matter.
Obliged. The service of notice on respondent paper for application is accepted. Let the appeal be listed for orders on admission. In order, if any, to continue till next date. Let the appeal be listed for admission in next week. What non-compliance? It's like Supreme Court has said it's time to comply with all. Learned additional comment that learned SPP based warrant is granted. How much time? By status. Non-publishing of PF. Non-publishing of process fee. 2 weeks preemptory. Tell him. Below cost type. But is the party you have not implemented, right? What has she done?
Not implemented second.
Not implemented second respondent. Not completed.
not seeking any relief against second respondent, that's why.
That can't be done like they don't decide. Just implement and then say. Takes time, comply with office objects.
Lord, I appeal for the appellant, please.
Undertaking, who is giving undertaking? Respondent is giving, you are giving undertaking. You are not giving undertaking. He is not giving any undertaking. Huh? Huh? No, you said he is giving undertaking, he is not giving undertaking. Now what? Huh? Directed to give undertaking. Why? No, you create complications, madam. You don't know how to file an appeal. You create complications and you tell us. Hold on, IA number. What is that, Mr. IA number? 1 of 2022. Current counsel correspondent respondent is granted 2 weeks time to enable him to file objections to the aforesaid IA in the meanwhile. Operation and effect of the impugned decree.
My lord, one submission, my lord.
Marriage shall remain state in next state hearing.
My lord, one submission. Your honor has given 2 months time to comply with your, to reconsider the punishment rod within 2 months of entire exercise. Is there?
Beautiful.
Number 14, Pradeep Eshavkar.
My Lord, I appear for the appellant in this matter, my Lord. My Lord, I have filed IA 1 of 22, my Lord. I don't press it because, my Lord, it is complied with on an apprehension that, my Lord, orders would be. Yes, my Lord, I don't press IA 1 of 22.
Appellant seeks leave of this court to withdraw IA 1 of 2022. Accordingly, same is dismissed as withdrawn.
Grateful.
The appeal has already been listed for listed that no orders are required to be passed on IA 2 of 2022. Accordingly, came up.
Grateful. Grateful.
Easier. Duration of delay. Office is directed to send a reminder to your records of the family court list thereafter.
16. Manoharacharya.
Contempt. What contempt? Supreme Court. Yes. What happened? No, do you understand? No, Mr. No. Do you understand that merely filing a special leave petition and keeping it pending for 5 years would not exempt you from responsibility of complying with the interim orders of the court? Mere filing of SLP does not operate as a stay of the impugned order. And we have given you sufficient time. It was April and today is what, November is also coming to an end. 11 months, 7 months if you can't do anything, then you have to thank yourself. No, we will send you to jail then. Right? No, you file SLP when you will be released when the stay is granted. We will send you to jail. Fine. No, nothing, no submission. April and November. You ask him to appear in person. Despite no suppression, she is your wife and you have to this thing maintain.
I'm ready to maintain.
Nothing, not ready. Not ready. This court by an order, mark the present, this court by an order dated 6/4/2022 had granted had directed payment of maintenance to the appellant at the rate of rupees 20,000 per month, and in addition had also directed the respondent to pay a sum of rupees 60,000 by way of litigation expenses. Thereafter, on 20 paragraph, thereafter on 22/9/2022, parties sought time to work out an amicable settlement. Thereafter, on 19/10/2022, respondent informed this court that he has filed special leave petition against before Honorable the Supreme Court against an order dated 6/4/2022. The in view of court's submission, hearing of the appeal was deferred. Again, on 9/11/2022, on 9/11/2022, none appeared on behalf of the respondent. Thereafter, on 10/11/2022, again respondent sought time to an order from Honorable the Supreme Court, line below. Thereupon, this court directed that the respondent shall either produce the appropriate order before Honorable shall produce the appropriate order before Honorable Supreme Court from Honorable Supreme Court, failing which a suitable order shall be passed. Paragraph. Today again, the learned counsel for the respondent seeks adjournment on the ground that special leave petition is pending. Full stop. Paragraph. In our considered opinion, more than sufficient opportunities have already been granted to the respondent. The interim order of maintenance was passed on 6/4/2022, and despite a lapse of 7 months, the appellant has neither complied with the order passed by this court, nor has produced an appropriate order from Honorable the Supreme Court. It is right law that mere filing of an SLP does not operate as a stay of the order passed by this court. Paragraph. The appellant, therefore, he will appear on non-bailable warrant. No, nothing. No thing. No things. There is an order. You have been heard. There is an order. You cannot again. What did we ask you? Whether he will appear or non-bailable warrant? Not appear. Huh? So tell him he doesn't understand, right? You have kept him this thing that nothing will happen. I will seek adjournment after adjournment. And I'm practicing only for seeking adjournments. No, nothing. This is what you haven't told him. He has not filed objection. No. So that no. So therefore, you are not required to pay maintenance, right? No. File a reply, Mr. The IA number 1 of 2022. Working means seek maintenance from her then. Working means, is she not your wife? Are you not under a legal obligation to maintain? What does it mean? Working means she should die. If she's dependent on you, she won't be able to survive because you are not prepared. What do you think? That she should stand in front of your house every day and beg for food? Working means what? It's good that she is working and self-sufficient. She is your wife. No, law of mandates, Mr. Law mandates that you cannot be permitted to flout the law. That be because she is working. See that man, he is a young man. He doesn't do anything. Let him go to jail then if he doesn't want to do anything. No submission. This is, Mr. You cannot be permitted to argue the matter pertaining to maintenance again. You have suffered an order. That order has to be complied with. Right? And there is an application for contempt. If you want to file objections to this, fine. Otherwise, we will refer it to contempt bench. So another like 2 weeks. Nothing. File reply. Why have you not filed contempt? Why have you not filed reply to contempt petition? So waiting means what? Who has Mr. taught you all this? That no, we are filing of SLP's immunity from everything. We want to hear from Supreme Court. We want to hear from Supreme Court that mere filing of SLP, you can get away with anything. Obviously, you know the fate of SLP, what will be done. You know, so you have kept it pending and seeking adjournment here without realizing that your liabilities, this thing counting. I think. Deal with it. Who is not non-compliance? Yes, sir. He wants to give the- By tomorrow, you file objections to contempt petition. Respondent is directed to file, despite line below, despite the fact that IA 1 of 2022 has been filed on 10/6/2022, despite a period of more than 5 months, 5.5 months, the respondent has not chosen to file reply to the aforesaid application. However, by way of indulgence, 2 days further time is granted to comply with office of to file reply to the aforesaid IA. Based on 24th, 30th November 2022, on the aforesaid date, respondent shall remain present. Tell him that he will not go home. Don't tell him that I will see and its SLP is pending. Don't tell him. Don't give him false assurances. Tell him that he has to comply with provisions of law.
Clothes and toothpaste, etc.
Huh?
Clothes, the toothpaste.
My lord is saying, ask him to bring clothes and toothpaste, etc., whatever. So from here itself, he may go somewhere, right? So ask him to come with full preparation, right? Here he may not go home. Tell him clearly.
17. Yeah, only I thought about
Plus, right? 70,000 views. Nobody is there, not interested.
I appear for respond number 1, your lordship, in this matter.
Why are you hearing, madam? 21 appeal. Not yet admitted. Let on IA number 1 of 2022, same is allowed. Let the appeal be listed for orders on admission in the next week.
14.
Print sent
Not for application. Yes.
condonation deals, but we'll have to see what is it. What's wrong in this? Huh? What? No, that we have answered. There's no question of full bench. Hey, Mr. You full bench or no full bench, right? The fact remains. You all people are arguing the same point over and over again. 11A does not apply. Even if there is no limitation prescribed under an act, that has to be done within reasonable time. What would be the reasonable time would depend on the facts of the case. In the facts of this case, we may have found that it is not a reasonable time. What is review? Take it further. That's what we have taken a view. I mean, you tell conflicting view and all that. No, we should not, we realize that we should not have used the word lapsed, but the fact remains that this thing. 2011, 10 years, you don't do anything. You want, no. Seized by Lokayukt, no explanation for not concluding the proceeding pertaining to acquisition for a period of 3 years. 2007 till 2010, what did you do? Nothing. Yeah, what? It may be wrong, Mr. There's nothing to review. Yes, yes, we are hearing you. You know, that's correct. We are not disputing. We told you the proposition as we understand in the beginning, no time limit prescribed, nothing happens. We should not have used the word lapse. But the fact remains, if no time limit, an act has to be done within reasonable time. Settled law. Right? What would be the reasonable would depend on facts of the each case. In the facts we have found, this decision does not lay down any law.
So it was a land vested with government under 88.
Oh.
Once the land vested with government, music rights are transferred to the government. We determine the foreign competition. Once property vested with government. Actually, mandate. Property vested with the government only after possession is taken. Unlike the KID Act, the property vested with the government even before possession is taken. And second one, the principle of reasonable time, especially not applying. That is already vested in the government. 25.
So you can do it after 25 years.
Then the question is just how much compensation should be paid, whether they could be 50 to pay.
No,
One day
like
to the other.
25 years also, then if that is, if we accept the proposition, you can do it after 50 years also.
But what I'm saying, the actual property, and on the property rights are already vested in the government. The property right, like the land acquisition act, the property right is still with the individual himself. If you have a property rights stop, they are no longer with the individual. And once the property rights are vested in the government, then you have this concept. That's right. But of course, between the 21, 24, or 50, what is the final of that? What can be what? But when property is already taken, this is no longer the owner themselves. Cancel it to revert ownership back to that. And what is there? We submit distinction right, which one I would say in fact the P is answer.
He can't oppose you,
Government
right?
supporting it.
Obvious, that's what he can't oppose you. All right, thank you. Oh, he always supports the petitioners. We know him. Yes.
Yes, Nagaraj.
1 minute. 1 minute, please give us. Mr. Dhyan Chinappa, learned senior counsel. So and so for the petitioner, just a comment clarification. Lakshmi Narayan, heard on IA 1 of 2022, an application seeking condonation of delay. For the reasons assigned in the application, duly supported by an affidavit delay of 96 days in filing the review petition is condoned in the result. IA 1 of 22 is allowed. But on the question of admission, this court is conscious of the fact. This court is conscious of the fact that in versus State of Karnataka, AIR 2000 Supreme Court 1113, the Honorable Supreme Court has held that provisions of Section 11A of the Land Acquisition Act do not apply to the proceeding initiated under the Karnataka Industrial Areas Development Act 1966. However, it is right law that even if no time limit is prescribed for doing an act, the same has to be done in reasonable time. So on facts of the instant case, this court has found that that there has been an unreasonable delay in concluding the unreasonable and unexplained delay in concluding the land acquisition proceeding. Therefore, the same have been quashed. Paragraph. The order of which review is sought neither suffers from any jurisdictional infirmity nor any error apparent on the face of the record warranting interference of this court in exercise of review jurisdiction. In the result, petition fails and hereby dismissed.
Thank you.
Ah, fine. Yeah, what is wrong?
We are only restricted to Banner and related Banner. In what type of Banners, all is possible to be very large. That's type of Banners. All is possible. So that they will pass it to award, to make sure. Again, I have produced it. This honorable court in 2013, in MFA number 6074, is granted the compensation to the age. Page 76. Property is available for also 4 acres, 92%. And acquisition officer. On the ground that land is related land. Hence, the appellants filed the petition, same was allowed, and by this court, with the direction to the land acquisition officer. Consider the request of the appellants. Thereafter, the land acquisition officer ordered the compensation at the rate of 3,200 per acre.
Yes.
3,200 per acre before the reference court. The claimants have produced the relevant documents in support of the case, but without considering the material record, the reference court disclosure of the without enhancing the award amount to confirm the award possible the land acquisition. Hence, the appellants before this court. Now, where the appellate before this court is enhancing from 3,200 to 14,250. Well, the very land acquisition officer given in the 2000 continuously passing the award relying upon this judgment and at the rate of 14,000. Only the fitting the petitioner's case and only they rejected the award to pass the awards only eliminated that. But the Honorable Court when passing the order restricted the order to the petitioners to establish the question of eliminated body lands as on the date of petition. But here, in the all type of body lands, there was even 2003. Restrictions. All the type of body lands. This is why I established my right over the property action. Copyright is also alienated body land. It is restricted to the rights of the people. It's rights of the people. The all type of other body lands are awarded. The award passed by the very land acquisition officer is produced at Annexure A, page 45. Translated copy is at page 48. And from 2003 also they will pass it there. Therefore, my humble prayer, it restricted only to the unlimited border rights. Yes, yes. Extended to all type of border rights.
Yes.
Because it violates Article 15 in all type of lands is awarded with the land, very land acquisition officer. And only this, that restriction is imposed to this particular petitioner. It's a clearly violation of Article 14 of the.
In this.
Total darkness. Oh, now you are in light. Huh? Huh? Not in dark, right? In light now. Obvious correspondent.
I beg to appear for respondent, my lord. And maybe
Why
have
you-
it 2 weeks
why-
later, my lord, I will file objection, my lord. Yesterday only he has given file to me, my lord.
Current counsel correspondent praise friend is granted 2 weeks time to enable him to file objections to IA 1 or
Please, madam.
on IA 1 of 2020. Notice record. Item number 19. For Mr. B.S. Nagaraj, learned counsel for the petition heard on IA 1 of 2022, an application seeking condonation delay for the reasons cited in the application form. Quoted by an affidavit, we find that sufficient cause for condonation of 20 days in filing the appeal is petition is made out according to delay. Alternate counsel, the petitioner order from any jurisdiction permitting or any other dismissed. Fishing of PF. He is not deliberately not
Password.
telling password. Password. Huh?
Each time
Each time. Why?
it-
No, he must have forgotten, like 3 years you have not argued on admission. So he has gotten barred by limitation. Ah, so you have served him with notice, right? Huh? Ah, good. Learned counsel for the appellate submits that he has no instructions to appear in the matter. The aforesaid statement is placed on record. Appeal is dismissed for want of court. Submitted for hearing. Record. What are you?
For maintenance.
Maintenance. You have filed. You have filed for maintenance. How much? How much was being granted by the family? You have filed reply to the direct counsel for the asset praise fund is granted a week's time to enable petitions YA 1 of 21 and 2 of 20. List thereof.
It's part of it.
Failed.
Next.
Pass over.
In serial number 25, appear for respondents, my lord.
Admitted for hearing.
Survive.
Learned counsel for the applicant submits that frequent events, nothing survives for adjudication in this appeal as the appellant has expired. You of court's submission, appeal is disposed of.
27.
Discussion allowed. Yes. What you have been held entitled.
Market price. Market value has been detected. He has paid the entire amount. In 2002, he should have paid it. In 2004, he has paid the entire.
Hold on, IA. 2 of 21 requirement was dismissed with not it. Issued notice on IA 1 of 21. Notice on behalf of party. Respondent number 2. Accepted by. To R. Yes. What? No.
Remanded by single judge year 21. The government has decided it after remand. We have to.
You decided after the remand. So after remand, has it been decided? The counsel for respondent prays for short accommodation to enable him to make a statement whether after remand the matter has been decided by the revisional authority. List on 30th November. Now continuation of delay. Yes. 28. No? There is a continuation of delay.
There is an interim order.
Interim order is in. Interim order granted on cell context. Appeal is admitted for hearing record. Fine. Dismissed. Appeal is dismissed. Appeal is admitted, madam. Appeal is admitted for hearing. Is there to argue, madam, in this appeal? You are seeking adjournment. No idea means don't come to the court. If you don't have idea about things, don't come to this court. This court. Wherever you may go, that's a different. Don't appear. We do not like the counsel who have no idea. Then what is it? I mean, why idea? Then do something else. Don't want to have an idea even about the appeal. Then don't come. No point in coming. It's not we don't come here to this urban park, right? Record. Is against an appeal against what judgment and decree matter? Is what now. So what does the law say? What does the law say? Appeal lies under which provision?
He lies under which provision? Let us, Mr. Tell, he lies under which provision? And how the read that provision? Ask her to read that. Tell her which provision, and she should read that provision. So section 19, how does it read? No, appeal does not lie under section 19. Something new. Give it, Mr. Record. She says appeal does not lie. So have you filed any application objection? No, objection to maintainability, madam, not objection. Then fine, be happy. Be happy. No. This is under Hindu Marriage Act. Passed by a family court. Appeal lies under section 19. Read it, section 19. And what is the locus of a respondent to oppose admission of an appeal? Admission is a matter between the court. She is not even arguing. We are admitting it. How does it read section 19? Read it for us, madam. We don't know. Read it. 19.3. 1. Where is it? Give it. She will not even read it. We have to read it. Very good, madam. You tell something and then keep silent. The court will find itself, right? That's it. Marriage Act.
Family Court Act.
We will impose a cost of 10,000 rupees on you for holding this court and making incorrect submission in case it is found that appeal lies. No, 10,000. Nothing. Yes. 19.1. Read. That's it. That's enough. So this is a judgment passed by the family court. Appeal does not lie. You said that it does not lie. That's why 10,000 rupees. 10,000 rupees. She alone can claim right to ignorance. You can't. She has the sole right, proprietorship right on ignorance. She has, because she doesn't know anything. How can you argue, madam, like this, that no appeal lies? Appeal shall lie. That's why we don't hear counsels. It lies by virtue of law. What is there to hear? She doesn't know. And she would never know. So what to do? But we have to. What is there to, and how can you file objections? We are admitting it. Go and file objection before Supreme Court. How can you argue like this? Surprising. How many years? 5 years. After 5 years, this is the output that an appeal does not lie. Under section 19.1, this is the output. The same order, admitted for hearing record. Admitted for hearing record. Admitted for hearing record. No inconvenience. He is there to oppose you. No inconvenience. That's not a ground. Today is Monday, right? Not Friday. No, there is an interim order. That's why this luxury. If there would not have been interim order, if they held up in, this is not court. This courtroom is not court. Huh? No. What we want to know is this not court? Huh? Is it court or not? Or something else? We always thought like it's a court. So you feel like it's not a court, then we are asking you what is it? No. Heard at length. He has to argue on admission first. Who is your senior?
Yes.
Where is? No, he asked you to seek an adjournment, right? Huh? No means what? At least say yes, that he did tell me to. How are you seeking adjournment? Sir? Huh? It counsel for the appellant prays for adjournment. Hearing of the appeal is referred list on 30th November 2022. It is made clear that in case any further adjournment is sought, interim order shall automatically stand vacated. Yes, November. Now you seek adjournment, we will grant adjournment. Interim order shall only continue till next date of hearing. And then it will stand vacated, Mr. You are at liberty to seek adjournment now. We have no problem. Yes. Please. Ready? Yes, that's what we thought, that you are required to argue. I'm ready. Ready? What's there? Nothing in your appeal.
The application was kept pending.
Huh?
On the ground that there was a criminal
Criminal
case
case
against an
pending now.
officer.
Officer, and
That
that
also
is
is
now,
acquitted.
he is acquitted. What is there?
He's acquitted, the state is still
Huh?
The BDA records.
Khata, what does it mean, khata? I mean, the prima facie evidence is there, right?
The same patents are not.
Oh,
That
Mr.
is
Now
not
we are
questioned.
not question. And there is nothing in this case. And perhaps realizing that you don't have any case, she's seeking adjournment. Trying to help you, right? How long, Mr.? You are meant for people. No. Are you day in and day out? We are strengthened in our belief that you have an anti-people approach and you are bent on harassing people. Number of litigation here.
I submit this.
Right? Number of litigation.
I had a. See, the
Nothing.
person who used to the same.
No, the problem is that the authority, if any other person is aggrieved, let him challenge it, let him do, we would have understood. Authority is under, they don't allow, they don't want to enter khata, change of khata. Why? God knows. Because he has not met your officers or sufficiently for a long time he has not met. So therefore, I mean, he should be condemned to death because he has made an application for change of khata. He could muster up the courage. So therefore, he should be harassed he is alive. This is the approach. We will impose now costs on this. Your appeals. No, repeatedly. A fourth occasion. If there is anything understandable, if proceedings for acquisition have been quashed, that is understandable. We don't. This is what poor people deals. He is making a application for change of khata, and you are after him. He has succeeded before. No. Now writ appeal. Now Supreme Court. So he should go wherever. So he should sell his utensils also of his house in litigation and pay fee to the clients, to your advocates. This is what it is. No apprehension. Nothing.
And 6 is the sale deed by the PD. 2006 is the sale deed. What have you done for the last 14 years? You have executed the sale deed. You have executed a sale deed. BDA has executed a sale deed in favor of Yashodamma. What have you done? And you don't want to change a khata in respect of the sale deed which you have executed. What have you done, mister? After 14 years or 16 years, can you tell that the signature is not ours? What have you done in respect of that sale deed? Not criminal case. What have you done to cancel the sale deed?
Criminal case, he has been acquitted, right?
16 years after sale deed. Cost.
Cost 25,000 cost. Nothing. No. This cannot be made a ground for adjournment. 25,000 cost. No, nothing. No apprehension. No, this is frivolous litigation, Mr. Frivolous litigation, and you are this thing bent upon, and they are participating with you in the process. Unfortunately, she is seeking adjournment for what? We don't know. Your appeal is listed for admission. We are not asking her a question. Despite that, she said, even before you can open up your mouth, she is seeking adjournment. For what you are seeking adjournment, madam? We did not ask any question to you. We cannot ask any question. Supposing if we ask any question to you, then you can say, I want an adjournment. Have pity on your client. Have pity. The court is ready to hear the case. Court is hearing, dismissing their appeal. You are seeking adjournment. Have pity on your client at least. We feel sorry for the person who you represent. He should see your conduct that my counsel is seeking adjournment to the court. That's why he has engaged you. No. It should remain pending for 5 years so that you keep on seeking instructions till everything he sells away everything. And eventually says that I don't have anything now. Give you. This is the matter. This intra-court appeal has been filed against an order dated 3rd of November 2020, passed by learned single judge, by which a writ petition preferred by the respondent has been allowed, and the appellant has been directed to transfer and register the khata in respect of scheduled property bearing number 292/E, 4th E block, Rishabhavati Nagar, Bangalore, in the name of petitioner within 2 months. Paragraph. Facts giving rise to filing of the appeal briefly stated are that that site in question was allotted in favor of the original allottee on 25/5/2005, and a registered sale deed dated 28/4/2006 was executed in her favor, and the possession certificate was also issued. Full stop. The original allottee, Srimati Yashoda, you write the name original allottee. Srimati Yashoda executed a registered sale deed dated 20th/6/2013 in favor of the respondent who submitted an application to the Hello Development Authority, transferred the khata in the name of the respondent. Full stop. The paragraph, the respondent thereafter submitted a representation on 5/5/2013. Full stop. The respondent by a communication dated 25/5/2017 was informed that a criminal case has been instituted against case worker in relation to allotment of the scheduled property. Full stop. The petitioner, therefore, the respondent therefore filed a petition before this court seeking a direction for change of khata. During the pendency of the petition, the respondent annexed a copy of the judgment dated 11/7/2018 passed in criminal case by which case worker was exonerated of the charges. The paragraph, the learned single judge by an order dated 3rd of November 2020 directed the authority to change the khata within a period of 2 months. Instead of changing the khata, the authority has filed this appeal. Paragraph. We have heard learned counsel for the parties at length. Full stop. Admittedly, the authority did not want to change the khata on the ground that a criminal case is pending against the case worker. However, in the aforesaid criminal case, the case worker was acquitted by judgment dated 11/7/2018. The sole ground for not changing the khata in favor of the respondent, therefore, had disappeared by efflux of time. Therefore, the authority, in the facts and circumstances of the case, ought to have complied with the direction issued by learned single judge. Instead of doing so, this intra-court appeal has been filed, in which we do not find any merit. The same is therefore dismissed with a cost of ₹25,000. The aforesaid amount shall be payable by the authority to the High Court Legal Services Committee within a period of 1 month from today. Admitted to hearing report.
It's some settlement.
Settlement. This intra-court appeal, this appeal has been filed against judgment dated. This appeal under section 19 within bracket 1 of the Family Courts Act 1984 has been filed against judgment dated 16th of January 2020, passed by the Family Court, by which petition filed by the respondent under section 13(1)(a), 13(1), then 1(a), small woman -A, the Hindu Marriage Act has been allowed, and the marriage between the parties has been dissolved. Paragraph, during the pendency of the appeal, the parties have arrived at an amicable settlement and have filed a joint memo. The terms and conditions of the compromise read as under 2 to 6, right? Paragraph, in view of aforesaid amicable settlement arrived at between the parties, the marriage performed between the parties is date performed between the parties on so and so, right? He is dissolved by a decree of divorce, and the appeal is
Already dissolved.
dissolved by so and so, and his judgment decree passed by the Family Court is affirmed. And the appeal is disposed of in terms of compromise arrived at between the parties.
7 lakh.
Amount of rupees just is affirmed. Your written judgment decree has been affirmed. In terms of compromise arrived at between the parties, the respondent has handed over a 7,50,000 dated 25th November 2022 to Learned counsel to the appellant, the receipt of which he has acknowledged. In addition, the respondent has also paid a sum of rupees 23,000 as arrears of maintenance to the appellant. You both together put it. 7 lakh and 23,000 as arrears of maintenance and get their signature. Get their signature. Take it, madam. If I what? Which case? What is it? Yes. Yes. When do you? All right. Tell us. Clear counsel. Learned counsel for the appellant mark presence. Learned counsel for the appellant press for short accommodation. Will prepare the case in arbitration list on 12th December 2020. We had read it. We had gone through the file.
No, the colleague who is handling this matter is undergoing some procedure in the hospital. I request for a week's upon.
Yeah, praise for it. Start. One time. 30 days, I praise for adjournment. To enable him to seek instruction. List on 13th November. Oh, sorry, 13th December. 13th December.
38.
Oh. What is wrong?
Even number.
Agree. You said you have no objection.
First, this is not very. It's not very. It was.
Then how are you concerned? Not in India won't be able to exercise the right.
Threatening we tried to review 28 days. It's threatening, we thought we'll have a looking at it. It's threatening the children that we might take it. There's a only concern. Bring the children.
No, rating, so what? Rating means what?
On the virtual call, today virtual call is going, and he is threatening that I can't take the children and go away. To the
No.
minor.
Where have you said? In the review petition, where is the affidavit? Threatening every day.
Page number 17, 18 and 18.
Huh?
Yeah, 18. Basics of the IA. One is communicating the children. That's one is
Let's see. unusual behavior, don't you think? As a counsel, as an officer of the court, right? I mean, see, they will hurl allegations against each other, they will level. Slightly unusual, right? It's your job to defend your client and then to say anything, whatever feel like. But you should behave as an officer of the court and this.
Degree against the appellant. The other side respondent readily agreed. I have no objection. We have for giving an opportunity. This is we allowed. He also said that we need meeting right. He immediately allowed because the appeal was being allowed. Now he feels it. Why did
Yeah, 1 minute.
why did you consent for granting the relief? No. You had consented the para 5, you read para 5 of the order. No objection for allowing IA2. No.
Because you owe a duty to be fair to the court. You are a young man. Therefore, we are telling you cases will come and go. But if you lose the face before the court, you will be in great difficulty.
The other side had agreed for allowing your appeal. And therefore, you had consented for allowing that application. Now, after your appeal is allowed, you file an application for seeking review.
No, that is not the ground of seeking review. We have seen the grounds in review. Who have blamed this court.
Yeah, you read the grounds.
Read
Where
the
have you
ground,
said that
where have
about
you said
threatening?
That is threatening, that's why I am. That after the in virtual call, he is making this. Threatening. You owe a duty to be fair to the court. Always remember. You will not get anything even if it is allowed.
The only concern is that this the brutality what he has committed over the children.
He is abroad now.
For it as well as IA1.
The respondent is abroad. And in the first title, the Bangalore address is shown. First title, Bangalore address is shown.
No, he's one outside. So.
This has been it. No, if anybody tells you I will commit theft, so you will prevent him from committing theft.
He has to be waiting because only country if he comes because he might come for Christmas.
This order is open to challenge. We have issued notice on admission and your IA. We are not granting you. Do you want us to say that no case for grant of interim relief is made out? Do you want us to say? We will say though and challenge it in an appeal for Supreme.
Sir. That means he has not complied and he is moving for contempt. That's why it is doing.
We can understand your conduct. Would appreciate your client's conduct and your conduct as well in encouraging her to file a review. Right? We understand. We have more experience than you. Right? How many years was the young man? 5 years. We have been judges for 13 years.
Yes.
So, and we have above, before that I have practiced for 20 years. We understand what is what. You are about to get a notice for contempt, so therefore you have filed this review. You are too young, right? Young. Too young. We understand. Thank you. Don't ask, we can dismiss this petition also. We can dismiss also. Don't be over smart with the court. Admitted for hearing.
Resolution.
Admitted for hearing. Third on IA. admitted for hearing heard on IA 1 of 2022 after hearing learned counsel for the parties it is directed that operation in effect of uniform judgment and decree so far as it pertains to dissolution of marriage shall remain state. Learned counsel correspondents may file objections to the aforesaid IA within 3 weeks. Office is directed to secure the record of the family. But this is the most unfortunate. You have, this is an appeal listed for admission, right? You have moved the memo and this, and thereafter you have.
Today morning I have written. No, I am physically I am. I did not know the name.
What is there to argue, madam? Appeal lies. Law provides. There's nothing to argue.
Yeah, I 3 days back, I have gone for some competition and I could not take rest also. Yesterday night I written. So reason I was thinking.
We are not concerned with all this. You should take this thing, take up the issue with your colleague. So why without notice he has taken this and he should have known that you are going and you are unable to stand up. Huh? You have to compensate. She is unable to stand up. Why have you troubled her? Huh? Sorry. Fine. Say interim order. Interim order earlier granted shall continue. Yes. IA is disposed of after hearing the interim order is made absolute. Accordingly, IA 1 of 22 is disposed. National court.
She's always good. National competition something.
You haven't gone for a national competition, right? You are able to stand up. Huh? That's better. Enhancement of permanent thing.
Only with regard to alimony and visitation rights.
Appeal is admitted for hearing. Record issue notice on of IA 2 of 22 and 1 of 20. You are seeking stay of, we have issued notice, Why? So you don't want children to meet the other parent, right? Why? So that's why we have.
You have issued notice.
No,
After service of notice, we will consider.
hold on, IA 1 of 22 requirement of right copy of the necessary is dispensed with. IA is allowed. What is it?
Stated in the form.
Huh?
You have granted an interim order.
Yes, mop up roundly appeared. Oh. To file objections. File. What order? Not order.
Fourth response.
Issue notice to respond number 4, right? And you file objection.
Shanti Bhushan.
Mr. Shanti Bhushan, Deputy Assistant Solicitor General, accepts notice on behalf of respond number 4. Tell him.
Seat has not been unblocked at their end, represented by the respondent.
We'll take it up. You tell him. Tell Mr. Shanti Bhushan what's. Why don't you contact Mr. Shanti Bhushan? Tell him we will take it up in password round. Password round we will. We are not going to unlock and lock, Mr. You understand? You know, Mr. Shanti Bhushan? Don't know. You are not practicing in Bangalore.
But I did not have occasion to know him.
You know Mr. Lakshmi Narayan? Huh? Mr. Lakshmi Narayan. See, he knows how popular Mr. Lakshmi Narayan you are. He knows you. Doesn't know Deputy Assistant Solicitor General of India. For India. You don't know. Tell Mr. Ramesh, tell him. We don't know what.
You have passed over the matter now. Please bring him.
Call him for him. He may not understand what to do. He doesn't understand you. Please mention, we will take it.
What's our matter, number 22?
See, I told you, they won't appear. They know. Yes, none for the, how we will file an application for recall. None for the petitioner, even when the matter is called in second round. Record perused for the purposes of admission. This intra-court appeal arises. This intra-court appeal arises out of a judgment dated 28th July 1998, passed by learned single judge, by which writ petition preferred by the appellant has been dismissed. Paragraph. The petition preferred by the appellants has been dismissed. Paragraph. Facts giving rise to filing of this appeal briefly stated are that appellants are grandchildren of the grantee. The land in question bears survey number 156/15 and it measures 2 acres, measuring 2 acres situated at Huli Mangala village, Anekal Taluk, Bangalore, Urban district. Full stop. The aforesaid land was granted on 14/5/1932. Thereafter, the first alienation took place on 23/8/1961 beyond the non-alienation period of 20 years. Paragraph. Yes, thereafter, an application was filed by the legal representatives of the grantee before the assistant commissioner under the PTCL Act. The assistant commissioner, by an order dated 15/2/1987, was thereafter the grantee, the LRs of grantee filed an application in the year 1987 seeking resumption of the land before the assistant commissioner under the provisions of PTCL. Right. The aforesaid application for the assistant commissioner, by an order dated 15/2/1996, directed resumption of the land. The aforesaid order was set aside in appeal by the deputy commissioner. Thereupon, the petitioners filed the writ petition, which has been dismissed. Full stop. Paragraph.
Bill is filed with a delay of 6,512 days.
See, writ appeal has been filed after a delay of 6,512 days. Paragraph. We have perused the record. Full stop. The land in question was granted on 14/5/1932. The terms and conditions of the grant contain the stipulation that the same shall not be alienated for a period of 20 years. After the expiry of 20 years, the first alienation of the land has taken place on 23/8/1961. Full stop. The application seeking resumption of the land was filed in the year 1987. 87
Delay of nearly 9 years from.
after a delay of nearly 9 years from the date of commencement of the coming into force of the provisions of the
PTC.
PTCL Act. Full stop. The Deputy Commissioner has therefore rightly set aside the order passed by the Assistant Commissioner inter alia on the ground that the land was alienated beyond the period of 20 years, beyond the prescribed period of 20 years, and the application was filed after a delay of 9 years from the date of coming into force of the Act. The order passed by the Deputy Commissioner neither suffers from any infirmity nor can be termed as arbitrary or unreasonable. To stop, the learned single judge therefore has rightly dismissed the petition. Paragraph of the aforementioned will be disappear. The same fails and is hereby. 1 minute, yes. Yes, 1 minute. Again, next. 25, what happened? Yes. 25 minutes.
25.
Yeah.
Technician.
And
Passed over because no, because an expert order we thought can be held back if he comes appellate. But say that he is not present and we release there after 2 days.
none for the appellant even when the matter is called in second round. This form. Except in December 20.
Party one.
Will be permitted to appear. Yes, intimate. Oh, what happened? Huh? You come running. You should meet him. You should meet him outside and offer him a cup of coffee. Huh? He should do it, whatever. No, because Mr. Shanti Bhushan will have to introduce himself to the gentleman. He doesn't know anyone. Maybe he's not practicing here in Bangalore. That's why. So, what have you given it to him? Mark the presence, learned Mr. N.K. Ramesh. Please give the communication. Copy you have to hand over, Mr. Learned counsel for the petitioner undertakes to supply a copy of the rate petition to Mr. H. Shanti Bhushan, learned Assistant Solicitor General, who appears for respondent number 4, Mr. N.K. Ramesh, learned counsel for the Karnataka Examination Authority, has states before this court that Karnataka Examination Authority has sent a communication dated 25/11/2022 to respondent number 4, and it has been stated that the petitioner has cancelled the allotment of seat on 27/11/2022. Full stop. Paragraph in view of aforesaid submission, learned learned ASGI submits Deputy Assistant Solicitor General states that the petitioner shall be permitted to appear in stray round of counseling. Right? Let objections, if any, on behalf of respondents be filed within 2 weeks. Yes, Sarah. Oh. Yes. We don't know. We had asked the council to correct. He has disappeared. Some new person is appearing today. Huh? Mr.
Erased.
Somebody else had appeared on behalf of the petitioner. Today, somebody else is appearing who doesn't know anyone here, except Mr. Lakshmi. He knows only Mr. Lakshmi.
In the court file, it is erased. File given to it is not.
Oh. Yes. He has corrected it. That issue we had taken up last date. So who is respond number 4? Right. Okay. Yes. Huh? What report? They covered. Not covered. Facts. What is there? None for the petitioner. None for the petitioner, Mr. Lakshmi Narayan Learned, Government Advocate for 1 and 2, Mr. Venkatesh Sarvati Learned Counsel for Respondent 3 and 4. Awaiting appearance of Learned Counsel for the petitioner, hearing is deferred. Just after 2 weeks.
Is there any interim order?
What is it? Yes. Which case? 69. 69. It is for, what is it? Representation not considered?
Child custody.
Child custody. Oh. Who you should. We will take up, not like we thought preventive detention. Child after all is in the custody of mother or father. No, not like this. We thought preventive detention. We take up, don't worry. Later half of the day you make. Oh, what for allowing the appeal? Which one?
Review order.
Review order. We thought like that only, Mr. That's why you did not tell us you sought the adjournment, right? We knew that you were focusing on review only, and what happened? Nobody appeared in the main matter. So we thought that we will make your review infructuous, but you have. Friday it is coming. Which order? Learned Counsel for. Mark the presence, Learned Counsel for respondent, Mr. So and so, Learned Counsel for respondent number 4 submits. But this is a 2009 matter. Learned Counsel for respondent number 4 submits that the respondent number 4 has filed SLP number 21442/2022 against the order dated 31st of October 2022 passed in RP number 402/2012. It is further submitted that SLP is fixed for hearing on 2nd December 2022. Learned Counsel for respondent number 4 therefore prays for short accommodation. List on 6th December. Whatever you tell, you have to argue. On that day, either it becomes infructuous or not. No, not infructuous. We will have to defer it further, or you will have to argue. These are the two eventualities. No adjournment on that situation, except if an order is passed by Supreme Court. So tell us 6th or 7th, what date? List on 7th December. Sorry, don't give it on that day. Who knows? We thought that you want your money back. Then give my money back. Huh? Okay. Yes.
SLP against the review. Review order.
Just litigate.
Probably very valuable, bro. What it for is small money.
No inconvenience. What? 2010, 12 years. You lose the title. What is the limitation of filing a suit for title in respect of any immovable property? Under Limitation Act. How many years? Limitation. No. We have asked you something. Get back on that. How have you become an advocate without reading Limitation Act? Limitation Act was not a subject matter of your curriculum. Then have you not read it? You have. So how many years the right gets extinguished? You tell me, mister. So how many years? You have lost lien over the case, nothing remains now. Like 12 years, now no adjournment, nothing. 12 years. Why have you sent her? You know, right? No, you know that this bench is tough in granting adjournment. Why have you made her stand? You are also represented, right?
Second appellant, he is for the first appellant.
Yeah, after 12 years, madam. 12 years, I mean, you should have told your senior, please do not send me to that court. You know about this court. You know. Do you know about this court or not? That we are allergic to granting adjournment in old cases. You know that, right? Then why have you come? They know what will we do of apology, madam. This is not contempt where we will accept apology. What is it, mister? Yes. You are appearing as if you are a contemner, like this. Why? Or you are relaxing. What? What is it? State. You are appearing for state. What is it about? What is it? At least tell us what is it about, mister?
Nice. Nice.
There. It will remain in the list, madam.
Direction by the Supreme.
Huh?
It's a direction by the Honorable Supreme Court to dispose it of early.
Honorable Supreme Court has directed this Honorable Court for early disposal. No inconvenience. Tomorrow. Make some arrangement tomorrow. Will not be adjourned. Okay. Nothing. Alternative arrangement can be made. 24 hours is good enough time to prepare a case. Go adjournment. No, therefore adjournment. Huh? So there is no stay. The Supreme Court has not said that the appeal should not be heard. No, no, we don't.
Stay is whether further proceedings or
No, no, no stay of further.
only the order is.
So that doesn't mean that appeal should not be decided. Go ahead. Huh? So you can execute, right, that. Your husband. Then you can execute that. No, no, no. For 2 weeks. Who told you this? Huh? Who told?
The only told is this.
Huh? Who told you that they will not pay? Submission is wrong, right? Submission is wrong. It says whatever amount is due under the orders of this court is executable. We cannot make you understand this. Cannot make you understand. There is no order of stay by Supreme. Supreme Court has not said that don't hear, High Court should not hear the appeal. Right? So you have to argue this is 2011 appeal. No, nothing. This is Monday. This is Monday. Not Thursday, Monday. Today is Monday. Don't look at us. You will have to argue the appeal. You don't want to argue, we will say that he doesn't, you don't want to argue. No, correct, right? Then nothing. That order we alone can pass, you cannot pass. Otherwise, you say list after 5 years and go home in your file, write down list after 5 years. But our order will, who will list tomorrow? No, no, not tomorrow. Tomorrow never comes. The section 9.
She'll be there. Respondents Council, Madam Pramila, normally she'll be there regularly today, her thing is she's not.
It has been dissolved, right?
The ground of cruelty. First, of the evidence, the single judges held that prior to marriage also she was under treatment for some mental illness. Only yes. Permanent element is correct. How many children? Only one. Boy or girl? Boy or girl?
Very interesting thing. But my senior problem is decided. That means lawyer not required to not three cases. Acumen of the judge. And this is the council make an impact. Attention, the with this one will be exhaust whether attention give your name guarantee success like 100%. You have attention. You're contesting you have to succeed. Give an answer. I have never understood. I will read it on this.
On the ground that he was taking treatment, which he has denied. So the husband, there is no other.
She admits. It's six. Okay. This thing.
On the ground that you are not taking the medicine properly and condition was aggravated. Afterwards, she was treating him.
Is that show the name of that council, Mr. B. Swami. Ah. What is your submission? Huh? You have admitted that you were on medication, right? Then and there is no material that this fact was known. I mean, but in any case, it has been granted on the ground of cruelty, not on the ground that you are suffering from mental disorder. 2006, you are living away. Since 2006, you are living away, right, from your husband. At this point of time, not possible. 16 years. Not right. Not when the case is called for hearing. So, how much permanent alimony you want? She's also employed. No. She was employed in Bombay.
That is prior to marriage.
In that you recover, Mister. We are not sitting here to recover here. That executing court is meant, right? We will grant you the liberty. All 2011 matters, 2009 matters, we should refer to mediation and retire. Very easy solution, right, Mister? No, nothing tomorrow. Forget about it. Tomorrow. Yes. Oh. Should have said 1 crore. Why did you say 50 lakhs? How 1 crore, right? People. As a judge, it is your whole responsibility. They tell us you are equal partners in the administration of justice, right? This is how you do it. So the entire burden is on the court to decide the appeal. You have not done anything. You did not argue the case. You have not done anything. This is how equal partner in the administration of justice. Whenever new judge is sworn in, you assure that we will go give full cooperation. Members of the bar, this is the cooperation you are giving us in deciding this appeal. Nothing. 50 lakhs, something 2 years ago. This is the argument. This is being heard finally, Mister. We are asking you to argue the case. Do you understand? No, nothing. Forget about it. That's all over now. You are not granting an adjournment in a matrimonial appeal, which is 11 years old. Let her file 25. Why should we grant her? No. What is the income?
Which we have taken it at 2,43,000 income. They said it is 1,29,000 take home. 45 is the salary out of 245. 129 is the take home, that is what is reported. Admitted income is 242 lakh, but
Make it 50 lakhs.
he had offered 20. He said.
Not offered.
Yes, yes, that's what he said. He offered 50. Okay. Pass over, then pass out. So, see, they come, so it will pass out. We'll pass over only to hear the other side. Anyhow, we are not arguing. Let us see
You
whether
don't
they.
want to argue. What can be done? No apology.
Hospitalized, she says. Tamila Naisar is hospitalized. He is hospitalized.
Also,
You want a passover?
why after 11 years, Mr. What is the justification? Huh? So what were you doing all along? I mean, we are hearing it. We are going through the file.
You were here, you should have told them. No, you were sitting from the last 20 minutes. You were here only. No, you were here.
Tomorrow. No adjournment. It will continue in the list.
Tomorrow.
That don't come. You are not obliging us by not by coming. Like this. Nothing to smile about in a case which is pending for 11 years. Have pity on your client. Have pity at least.
Tomorrow.
I appear for the appellant, madam.
I appear for the respondent.
Original respondent was a middle management grade 2 officer of the bank. Appellant is the bank, State Bank of Mysore. But
Was similar matter we disposed of. The two matters regarding State Bank of Mysore.
Mr. Rajgopal,
yes, madam.
Yes, my
Respondent
lords.
under
we have disposed of a similar matter, right?
No, that is not, there is slight difference here, my lords. Here under regulation 19, sub-regulation 2, managing director alone is having the power to continue the proceedings beyond retirement. Order next B, my lords, is passed by the chief general manager exercising the powers of managing director.
Acha.
There, my lords,
Power under
my lord, sir. Power under regulation 19, within bracket 2,
yes.
can be exercised only by the managing director. That regulation, my lords, is extracted at page 218.
Yes. What has been done?
Now, my lords, Annexure B order continuing the directing continuous the disciplinary proceedings is passed by the chief general manager exercising the powers of the managing director.
There is no provision for delegation.
There is no provision for delegation. And the bank admits that the power is of the managing director. It has been exercised by the chief general manager. My lords would get their finding at page 231.
Right, so this has to be quashed and the liberty has to be given to managing director.
No liberty may not be available, my lords, because the employee is dead during the pendency of the appeal.
Oh. Yes.
And
I
I
think,
have placed on record, my lords, interpreting the
I
very
think-
same. That's all, my lords.
oh, that's how Mr. Rajgopal we appreciate. I'm like, in 2 minutes you have concluded. That's what we appreciate. This is the
Grateful,
only,
Lord.
yes, thank you. Yes.
My lord should say, my lords, I have placed on record a
Ah.
judgment of the division bench of the Punjab and Haryana High Court, which interpreted the very same section, my lords, 32 and 35 of the State Bank of India Act. Central Board of Directors, they can appoint an acting, but they have not done in this case. As my lords would guard this soul, my lords, the question of delegation does not arise.
So, which judgment, Mr.?
That is, my lords, that is at page 200 and
In this compilation of judgments.
in the compilation, my lords, that is Haridwari Lal versus Union of India, page 341.
Yes.
At para 9, page 349.
349. Para 9.
Para 9. Managing Director of the State Bank of India. Then, my lords, para at page 73 in the same paragraph, section 32, which empowers the State Bank Board to appoint an alternate to
Page.
person, page 351, my lords. Section 32. In case the managing director is not available, incapacitated due to illness or his term having expired, State Bank of India has to appoint another person to be managing director. That has not been done. Chief General Manager exercises the power.
Where is it? It is held, it is impermissible. Which para?
Which minutes it is impermissible minutes. The that is at paragraph 26 minutes, page 355. Para 26.
And
Here there is no ratification also.
all right. So facts have been mentioned where?
Facts have been mentioned, my lords. 30th June 1999, I retired. Before my retirement, I was placed under suspension on 13/11/98. In the list of dates and the events, my lords.
You
Yes,
have given
Manoj.
it here.
Yes, my lords. Yes.
That's the point.
Charge was filed. Charge was filed while you were in service. Then inquiry was conducted. Inquiry officer held out of the 21 charges, 18 are proved, 3 are partly proved. Then a copy of the inquiry report was given to him. He submitted his reply. Disciplinary authority found this satisfied, therefore passed an order of dismissal. He filed a statute review also. Now, this question which my learned friend raises now before this court, in the writ petition, no mention at all about that. You have to find the input or a common order was passed in respect of 2 employees. That is the present appellate and also officer Vijay Bank. And as far as the learned single judge, the lots of case, reasons assigned.
Hey,
Page
Mr.
40
Rajgopal, 1 minute, 1 minute.
Page
Rajgopal,
53, I have raised this.
1 minute, 1 minute, 1 minute. We have understood that, I mean, before punishment can be imposed, superannuated, right? Is it correct?
I say, my lords, now after dismiss, after retirement also by virtue of subsequent judgments, after the learned single judge passed on,
Continue.
dismissal
Yes.
can be imposed.
That's what we have held in your case. It can be
That-
imposed. But
That
the
is, it can be imposed. That is the ground on which the learned single judge allows the writ petition.
no, but
That
your
may not
contention,
hold good.
no, contention which you are raising is, as we have understood, is that the chief general manager has directed continuance of disciplinary proceeding after your superannuation,
Yes,
whereas
ma'am.
under regulation 19(2),
Yes,
managing
ma'am.
director was the competent authority, right?
That is the condition.
That's it, Mr. So what? Yes,
The Rato finds
attention, where have you raised page?
Page 53.
Page 53.
That's
And
it.
also in my appeal before the appellate authority at page 218. And in reply to the charge sheet, I have raised it at page 86. At all stages, I have raised it.
So ask the other, there seems to be a difficult man. So, is the point.
Yes, Mr. Narasimhan.
Yes, ma'am, Rato finds at page 53 of the paper book. This
Yes,
is what
that-
is stated.
That ground has been raised.
The repection, this is what is stated. In
That
case
ground
of
has been raised, regulation 19, it has been. that ground has
stated,
been
these
raised.
regulations, these super proceedings may at the discretion of the managing director be continued and concluded by the authority by which these proceedings were initiated in the manner provided for in the state regulation office to and so. It is now well settled that disciplinary proceedings can be said to have been initiated against officer only on the date on which the charge sheet is filed.
That
This is not
another-
extracted, nowhere a finding is given. Only the regulation is extracted. Nothing is stated in the question.
Itself is 53, it is quoted. Regulation 19 is quoted.
Yes, please.
In the appeal before the managing director also, before the bank, I have raised it at page 218. And that is rejected by the bank at page 232, paragraph 4.
Father Shankar.
Great.
Yes.
That's all the ground, my lords. I
Ah,
can't.
yes. So when you appear, we expect you to conclude in 5 minutes. Not more than
I
that.
concluded, my lords.
Oh, yes.
Because
Mr.
he
G,
raised a question that I have not raised it, therefore I had to come back to.
yes, Mr.
Get page 47 of the order of the learned single judge. This is what is stated. The court is of opinion that the scope of regulation 23, which enables the employer to continue inquiry against a retired employee even after retirement, is only to enable the completion of the inquiry for the limited purpose of enforcing the permissible revenue to correct. This is what is stated.
The other
According to the
side,
learned single judge,
the other side has argued that the section, regulation 19(2) is not complied. What do you say about that?
regulation 19, chief manager has done it, but not the managing director. That is, there is no difficulty about it.
But as
But
per
only thing is,
19(2), it is only the managing director who can do that.
but the learned single judge at page 47 of the paper,
Single judge, what is your answer for the other side's argument? Regulation is very clear. It is only the managing director who can do it. Now
he would have
during,
granted permission,
Yes.
but he has died.
now during the pendency of the appeal, the employee is no more.
no more. Only thing is, he had got the monetary benefit from the advice was alive.
Where is that order, Mr. Rajgopal, Annexure B? Directing.
Annexure B
continuing-
is at page 50. No, the Annexure B is page 72.
Bernard single judge has accepted his contention.
No, he has not considered this contention. He
But
went
consider-
on the ground that punishment of dismissal cannot be imposed after retirement. That is no longer good law, my lords.
Where is
Therefore, I have
the
to,
Mr. Which we have given in your case, is that number? In this case,
writ appeal 3459 of 2011. 3459 of 2011. Vijaya Bank versus Saitab Shetty.
Yes. That's it, yes.
Common order.
That's it.
Common order passed at page 20 of the papers. Attappa Shetty Vijaya Bank, that was separately dealt by your lordships.
Ah,
Page 20. Attappa Shetty versus Vijaya Bank. Another is Vasudha Tathatar versus State Bank of Mysore.
Right now. Mr. This intra-court appeal. Section 4 of this intra-court appeal. This intra-court appeal has been filed against an order dated 9th of March. By learned single judge in WP number 38466 part 2000, which the disciplinary proceeding initiated against the respondent request the learned single judge on the ground that the proceeding not have been continued beyond superannuation, beyond the age of superannuation of the respondent. Full stop. Paragraph. Full stop. In order to appreciate the grievance of the respondent, few facts need mention which are stated in front. Facts leading to this appeal briefly stated are 3846
Page 27.
Facts giving rise to filing of this appeal briefly stated are that respondent joined the services of SS State Bank of Mysore, herein after referred to as the bank. Year 1962 as a clerk. Full stop. The respondent was full stop. The respondent since deceased, right? Now he's dead. Since deceased, respondent since deceased was placed under suspension by an order dated 13/11/1998 on the ground that a disciplinary proceeding is contemplated against him. Full stop. Contemplated against him in respect of certain acts of commission and omission ought to have been committed by him while the deceased respondent was working as manager at MES College, Bangalore branch of the bank, full stop. The disciplinary authority, full stop. The
Superannuation
full stop. Before that. 36. The chief general manager of the bank, by exercising powers under regulation 19 within bracket 2 of the State Bank of Mysore Officers Regulations 1979, hereinafter referred to as the regulation. Directed that the disciplinary proceeding already initiated against the deceased respondent shall continue. Full stop. The respondent attained the age of superannuation on 30th/6/1999. Thereafter, a charge sheet was issued to the deceased respondent on 25/6/1999, and an inquiry and a domestic inquiry was held against him in accordance with the regulations. Full stop. An inquiry report dated 15/15/2002 15/2/2002 was submitted in which full stop. The respondent thereupon submitted a representation to the inquiry report. The disciplinary authority, by an order of the penalty of dismissal from service, the said order was affirmed in an appeal by the appellate authority. Paragraph. The deceased respondent thereafter filed the deceased employee, hereinafter referred to as deceased. In the beginning itself, you say the deceased employee thereafter filed a writ petition before the learned single judge. By an order, by a common order dated 9/3/2011, passed in the 38466 part 2000, inter alia, held that after the death of the appellate, death of the deceased employee, after the death of the employee, after superannuation of the inter alia, held that after the superannuation of the employee, the departmental proceeding could not have been continued against the deceased employee. Accordingly, the writ petition was allowed. Stopping the aforesaid factual background, this appeal has been filed. Paragraph. Learned counsel for the appellant. Learned counsel for the appellant submitted that the learned single judge grossly erred in holding that after superannuation of an employee, a disciplinary proceeding cannot be held. In support of aforesaid submission, reliance has been placed on decision of Supreme Court in Canara Bank versus DRP Sundaram. DRP Sundaram. 2016 bracket close 12 SCC 724. It is however first one. DRP. However, it is fairly submitted that power under regulation 19 within bracket 2 regulations has been exercised by the chief general manager and not the managing director. Paragraph. On the other hand, learned senior counsel for the respondent submitted that the employee has expired during the pendency of the appeal. It is further submitted that the order dated 7/5/1999 passed under regulation 19 within bracket 2 of the regulations is per se per se bad in law, is per se without jurisdiction as the same was not passed by the competent authority, namely the managing director. Full stop. It is further submitted that in the absence of any provision for delegation of the aforesaid power, the same could not have been delegated to Chief General Manager. It is submitted that since the employee has expired, therefore the matter may not be remitted to the authority. Matter should not be remitted to the authority. Should not be remitted to the authority. Paragraph. We have considered the submission by learned counsel for the parties. The factum of death of the employee is not this factum of death of employee during the pendency of this appeal has not been disputed Full stop. Before proceeding further, it is appropriate to take note of regulation 19 within bracket 2 of the regulations, which read as an page 18. This orange flag here, 218. Thus, from perusal of the aforesaid regulation, it is evident that under an order passed by the managing director, a disciplinary proceeding may be continued against an officer after his superannuation. In the regulation does not contain any provision with regard to delegation of power. Full stop. In the instant case, paragraph. In the instant case, admittedly, it is right law. Paragraph. It is right law that when a power is conferred on an authority by a provision, that authority alone has to exercise that power. Full stop. See so and so. 1952 Supreme Court, page 16. Commissioner of Police versus Govardhan Das Banji. 1952 AIR 1952 Supreme Court, page 16. In the instant case, admittedly the order dated order under regulation 19(2) of the regulations has been passed on 7/5/1999 by the managing director. Full stop. By the Chief General Manager. Full stop. In terms of regulation 19(2) of the regulation, Chief General Manager has no authority to pass an order under regulation 19(2) of the regulation. The aforesaid regulation is the aforesaid order is therefore per se without jurisdiction and therefore cannot be sustained in the eye of law. Paragraph. Ordinarily, we would have remitted the matter for consideration to the managing director afresh. However, in the peculiar facts of the case, since the respondent has expired during the pendency of this appeal, we refrain from doing so. Full stop. Paragraph. For the aforementioned reasons.
J and K have to be set aside. J and L. Penalty of dismissal has to be set aside.
Not in my appeal.
It is
Penalty.
No, you have succeeded, right?
Yes, my lord. The writ petition should be allowed.
Has been allowed by the court.
No, it has already been allowed. Yes.
Yes, my lord.
Paragraph. Paragraph. In view of law. In view of law laid down by Honorable Supreme Court in Canara Bank Supra, we hold that the disciplinary proceeding could have been continued against an employee even after his superannuation. However, in an appeal, However, this court in an intra-court appeal on the analogy of powers, on the analogy of principles contained in Order 41, Rule 33 of the Code of Civil Procedure has power to make such order which ought to have been made, and that power can be exercised notwithstanding the fact that no appeal has been filed by the parties against such an order. Paragraph. Therefore, paragraph for the aforementioned reasons is he has succeeded, right?
Respondent has succeeded.
Succeeded. For the aforementioned reasons, we agree with the conclusion recorded by the learned single judge, though for different reasons which have been assigned by us supra. Paragraph. In view of preceding analysis, we do not find any merit in this appeal. The same fails and is hereby dismissed.
Appeared for the respondent.
My lord, I am sorry, my lord. I wanted to get ready, my lord. I was discharged from hospital 2 days back, my lord. I have some problem with the health. Well, I want 1 week's time, my lord. Sorry.
No, it's all right. So what?
Miller, could we have it on 7, Miller? 7.
I have, we'll argue it.
Next week, my learned friend wants. If you can have it on 7th, I'll be grateful.
I had
Yes,
some,
7th.
because of the health reasons, my lord, I am making an.
No, 7th.
I'm not opposing it.
No,
I
7th
wish you all
November.
Yes, my
December.
lord, it is, my lord, I will do it on that day.
Or any other date my learned friend wants, because I don't want trouble because he has just come from the hospital, therefore.
You tell us, Mr. So both
My lord,
of you
your lordship
My
can have it on
learned friend wants.
7th December, my lord.
Huh?
7th
Seventh.
December is good enough.
Learned counsel, learned senior counsel for the applicant, praise for short accommodation. List on 7th December 20.
Much obliged.
Obliged.
Yes, yes. Cash means. Yes.
Was passed in 25/9/84. That is in respect of 39 members of land in circle number 9. Chiniwaguru village, Beku Hubli. For the purpose of formation of a residential area called Chiniwaguru Tank Pit Beach surrounding area. The final notification on 23rd, 1988. But award was not approved.
It was the award passed. 28/9.
1985. It was not approved.
Why?
Position was also
No, no.
not taken.
Who did not approve?
But then the engineer inspected works when the industrial elect that unauthorized constructions are come up.
No, who did not approve the award? Deputy Commissioner. Why?
First, unauthorized constructions were there. Before the award was not.
So this 14 WP number so and so final notification. Allow us an award in full check on.
Award.
10 months. At 27 July. July.
February 2004.
February.
By one Rama Subbarao.
Yes,
That is his.
Number 5.
That is his sign up. And that is.
We were looking at this, you know, that date was not there. Okay.
27/2004. Country Rama Subbarao purchased the scheduled land from the land owner Dwarka. Land was converted for non-residential. And here it was, the petitioners have purchased it on 10th of September 2009. Petitioners before. They are respondents here. They purchased it. So the petitioners have filed the whole petition 2nd of November 2009. The filed state objections. Because the other single case disposed of on 1/10/2012. Not taken.
Citation, Mr. No. The new citation. No, no, I mean, what is this line law? Supreme Court 9/1.
Appears respondent number 1, original petitioner. Right petition claim the right taken on request to the land sale person on agreement is that it's shown to shown. Position of law. Even if by itself does not confer any right taken on it. During the counter noted the likeness of the transaction. Said dated 22/5/2016. A specific fee was taken on behalf of the authority. The locus of original petition. However, the report is not at all. Considering the fact that the 2016, considering the fact that the notification of 64 Act 1894 was issued on 25/11/1980, there was an apparent that the original notification derived the interest of the land question. Much of the point number 1, original petitioner
That's it. Cannot be. Next. What is the citation on the? Yes.
And we will delay to offer possible explanation for delay. Court has also held that the delay of the period will be important to the qualification. The expired land has been partly and wholly related.
Only two grounds. One is subsequent purchaser. How can you challenge at the what? Not the answer. Also, answer is that both are parties. Original owner and subsequent purchaser.
Original party dependency of the petition was implied.
And what about delay?
Delay is not. Delay.
Because you are taking a plea of lapsing, they didn't do anything, therefore you can.
This court was part of the delay. The directed to pass out. Page lot 115.
Yes, he told us.
Where is it allowed?
Award could not be passed.
That has to be allowed.
Told us.
I don't know if well, I don't know. You want to make. Never informed. Because the check can't be taken, hence no awarding marks. Okay. What is the reason of they should explain what it was.
Then
1810 to the 4. 141. Request about a fast and the people. Technical opinion of the PDA and its government. Then 141. Copy is also blood. Because copy is also given. It is not very. Then after that, the that is so. That is taken by the federal government. The Maharashtra. Then technical authority can issue God. The no objection.
what? One of 19. Yes. Also, statutory permissions have been granted to build it. But he cannot confer title on you. Deputy Commissioner, if he of BPMP has no power to confer title on you. What happens with part not till today? Proceeding in which no awards are despite direction issued. They are all mixed up with officers and this thing, they are builders. They must be happy managing things, we understand. But what is the effect in law? He all has obtained statutory approvals. So we know how he must have done it. Not difficult for us to envisage. But the legal question is what, despite direction, no award, what happens?
Enforcement issued by the video to effect of authorized construction.
So what, you should have passed an award. Who prevents, is that a ground? That unauthorized construction is there, therefore award cannot be passed. You take a recourse to that, you should have taken recourse to public premises. Eviction of unauthorized occupants act against them. What if you don't pass an award? Obviously, they have managed. What is the effect? So supposing if the petition is not there, he has no locus. What is the sanctity of the land acquisition procedure? The fact remains that till today you have not passed an award. 11A would not apply.
No.
Why? It says no. 11A applies to BDA. No. It doesn't. No, fine, offshore. Fine, but offshore also. Reasonable time. What would be the reasonable time? 85. 88. 88. Fine. But the fact remains that you have not passed an award till today. Yes, that's it. That is not, we don't know. I mean, what it eventually depends on that. Those permissions, etc., they will not confer any title on you. Multi-storied building. Question is multi-storied building. Huh? Which page? They have said it can't be passed. What to do? What, Mister, what is award cannot be passed? Where? 5/7/2004.
25040.
No, Mister, but your rate petition is not maintainable, right? What can be done? Whatever your rate petition is not maintainable. No, no. Original owner was not there, not there. Subsequently completed. And what locus he had after having sold the property? You filed the petition.
Got completed subsequently. Was not there originally. It is not a petition filed by him. Yes.
That's all. What else? Time is up. One. That's all. Anything else? Hey, what? He decided complicated matters in no time, and in the simple case in which he has just raised two contentions, what he has to argue, right? You told us no delay. There is no part, no delay on your part. They are responsible. What else? Which order?
Yes.
First instance of
To argue at leisure.
afternoon.
G. Lakshmi Shra.
Yes, I know. 24/7/2012. The detailed order. After contesting by VDA, allowed the Virgin order to come on. Guaranteed finality.
That order is subject to challenge in this writ appeal. All interim order and final order can be challenged in an intra-court appeal, not final.
But they not question that order. What they say is subsequent purchase, that's all. They never say what Virgin order is there in the appeal. And the appeal.
That's what he has argued. He has relied on the case law.
That case law, if Virgin order is not there, it will agree. This for your lordship is that whether original is a party or not, the 620 are not original. If they are party,
The order means he can challenge the acquisition proceeding even after selling the property. What locus original owner has.
if your lordship permits me, I produce that order. Detailed order I produce.
No, we have that order. Single judge.
It is not there. File is not, it is there. File is.
We will get it. Don't worry. The records of WP.
24/7. 2012.
41124 or 1126 of 2011. Yes.
Keep it down.
Yes.
Order dated 22/12. If you want to permit me, I do the order. Is there on the order?
No, it has been allowed. Nobody is disputing. He didn't say that neither we are disputing that it was not allowed.
So I am reading only for the purpose of the VDA accepted that order and it has never said not original order is not there, not in the only they say
you say that this order has been accepted by BDA.
and there is no field not in the writ, only 50 purchases are there. That's what it means. No, my lord, there are two endorsements I have read. Page 120. Another is not page 156 and it is second endorsement. One of the pages. One of the requirements here is petitioner will on verification of the document, notification available in the land acquisition step of the authority and in 39 days of
Very nice building. Very nice building constructed. That's what I mean. These submissions are so lengthy. You can't afford to be brief because of that building. Yes. Page 153. We have read it that no award has been passed.
This is second endorsement given to the one of the respondents. On 19/5/2009, there are two endorsements, page 120.
You know, their officers the case lacks this thing intent on the part of officers to acquire the land. That's the problem.
It is not a problem, Lord. Kindly take the entire order sheet produced before you by the VDA has given me, page 247. And take now, whether under the partition or in law, they can't do anything. Page 249. Now officer has given opinion, but only not the VDA.
But that opinion does not bind that court. whatever he has been good to you, that's all we can infer. How you have secured this opinion, your experience should tell you.
I have not obtained.
We all understand how these things are done.
The
Fine.
High Court disposed of WP filed by the petitioner, paid them directly to pass award and pay compensation. As per its entitlement in the period of 2 months on the rate of the order. High Court has also awarded cost of 5,000 payable by the Supreme. Petitioner contended that property was acquired as early as 1988. No award has been passed. On 16th and 23, the petitioner has given documentation. The award has not been passed. He has been deprived of the property illegally. He has also taken the documentation. For any reason, BDA is not willing to make an award at the existing market value of the BDA to release the property from acquisition. That also relies business reported in INR 3 Fine was referred to DCLA, the order of the High Court, also on representation. As per para 33, property was inspected and qualified into SNO and DCLA. And it is reported as there are unauthorized construction, areas built up, and also people are residing, it is not possible to take possession of the same before the layout and make an award. It is in the record where we given the name of an award was made 4890 SNO of loan was a joint SNO and he is as per the court, this land is partly covered with structure during some vacant land. Vacant land will be acquired after leaving the previous year. But go further to living the table. Approval of the order and issue notice to owner to take possession. Another amount of made on 29/9/95 in SNO UDA, but they have not been. Again, and there are and take physical. So, in the award is cost, the UDA is very like the land for the construction. It is a design and therefore may not be beneficial to the authority, as the authority will have to pay heavy compensation unnecessarily in your business area. It will be noted that and notified as early as 1988, still no award was as required under the the question rehabilitation of the occupant may also arise. So, in circumstances, things it is reported by SA and AA that it is not possible to take physical picture, it is not feasible to make a war, and as such, God did not be passed. This is particular has given representation of 16th and 28, and also may be issued again with intimation submission to the High Court explaining the conclusion to which award. This is not law officer. Then the order. Far back in the year 2004. Then the order. Page 288. And second endorsement is issued to one of the LAC file is not landing to the level. Is notified for attention. Amazing of but giving our candidate and
Dwarakanath is not your vendor. He's not your vendor. Therefore, he had no right or title interest. Nothing he had as on the date of filing of writ petition. He's not even your vendor.
Considering all those, considering all those aspects, in the year 2012, after BDA filed objection to the application, allowed including detail of BDA not file any appeal. No, my lord, even in the writ appeal also they don't care.
Purchases cannot. Independence of the position of
But in the writ appeal, they don't deny my lord original knowledge. And if he pays several PD, and if he got that out. Was notified Karnataka of interest petition of 4 petition. As per the order of this one, dated 24/7, page not 7.
Illegal in case. So what's the legal position like? In the interim orders, we want to know you are a senior counsel of this. No. We want to know that interim orders passed during the pendency of a writ petition cannot be challenged in an intra-court appeal. This is the submission. And separately, it has to be challenged. Otherwise, challenge goes. It cannot be challenged in.
Where is the pleading? In the pleading, they don't say the Lord, not that the landlord is there. They don't plead not the subsequent purchaser, therefore dismissing. That those pleadings are not there. Understand, Lord, pleading is there at least in that state. I think it is there pleading. But the Lord is right, they can. But in the entire pleading, they are not pleading. Lord, they only say, Lord, para 14, Lord, they quote the Kantama's case, etc.
Where is your statement of objection? Which page?
Page 220. They finally, well, 15. Thereafter, I find application for appeal.
We have understood. We have understood that elaborate order and that has not been challenged. There are no pleadings in the appeal. So it has become final. It is binding on them. Therefore, petition is maintainable.
Yes, because there is no pleading.
Fine.
Yes.
Also, that second question. Come to second question. Now delay. That's what he is arguing. There is no delay on your part.
There is no delay on your part because so will be pass an order because petition number 4 direct them to pass award, not pass award in May, but anti-mediate acquisition in more than 34 years. No, alas. No, conversion order.
You read ground number 19 in the writ appeal. Yes.
Yes, sir.
Ah.
Use for any end. Include or pass everything this result in situation where the children purchase invariably is concluded with execution. Thereby impact is quickly. The include go. The way of amendment cannot do a very determined. And who are educated and
Therefore, there is a ground.
You said no ground.
there is a ground, but that order is not questioned.
But you tell there is no ground. Just now you said no pleading.
No, my lord. As far as your delay is concerned, Lord,
No delay.
I am relying upon Lord the decision of this court. If the first order, Lord, Lord, what is not passed to the land is 2 years. The acquisition of the lands and maps. Generally, not and acquisition. Line 11, 22, 29. I will give the next statement is not your loss. Identity the set of facts. There are two unknown facts are stated. Permit me, I will read the facts and then Lord. Then Lord, conclusion is finding it start from paradigm. Page 19, para 9. We have considered the submission.
Para 12, page 22.
However, in the instant case, preliminary notification was issued on 59, whereas the final notification of 28 KID Act issued 13.2. Even after a period of 7 years, rate of decision is given bench this court. On 15/10, no action was taken by KIDB, concluding proceedings, and no explanation has been offered. The delay of 7 years. Concluding proceedings. Therefore,
28 September 2022.
absence of any explanations of the delay,
681.
and
70.
and the forest land on a point of time. The third judgment not required to the bench not examining the approval of them. Here they admit not award is not approved, not third judgment is I don't read it. That's all. That's what
Yes. That we know this. Please say. We know 11.8 does not apply. So you can do anything anytime. time limit is not prescribed, does that mean that even after 25 years, you can pass an award 50 years? No time limit is prescribed. You can celebrate Diamond Jubilee also 75 years after pass it. What does it mean? Yes. Yes. Thank you.
For the respondents in this matter. For the respondents. Mr. Rajgopal is appearing against me, my lord. He is for the appellant.
Sir, you are muted. Please unmute, sir.
Mr. Rajgopal.
It is unmute only, but I don't know somehow.
Number 49, Sri K. Puttagowda. Council. Number 49.
Yes, Mr.
Sir, serial number 49, Sri K. Puttagowda. No, sir. I appeal for the appellant's counsel.
Yes.
Lords, if I could go on with this matter day after tomorrow, my lords. Today I have some difficulty, my lords.
The senior counsel for the appellant raised for a short accommodation list. After you wanted 30th November.
Great. Great. 50, the MS Purushottam Rao, the Arvind Reddy H, Government Advocate Sri K. Krishna, the B. Muralidhar, the Holla and Holla, whatever.
They are giving you a walkover or what? Not appeal. Appeal has to be dismissed. What? Also,
Number 51, the H. Mustafa.
yes. Land acquisition proceeding. There. Remand that came up before me. So she told me in that context. She understands. Crash the endorsement. Yellow zone. What's wrong with the order? Or what's wrong with the order passed by Learned Singh? Nothing wrong, right? Yes. Huh? Ah. Not directed to issue of tenor. Directed to consider the request of petitioner as forwarded by Deputy Commissioner for no objection within 6 weeks. What have you done? 6 weeks, now 6 years, and how many? Now almost 12 years. So, interim order. When was that passed? 8/6.
Yeah, planning for a new master.
What happened? Revised master plan, what happened? 2031. There is a direction, right? We also direct BIAL complete preparation of revised master plan as expeditiously as possible. So this was in 2016. So why? There is no 2221. Yes. So what is wrong, Mr.? The order, we haven't got it still. Opinion rendered by you. By you means advocate, as an advocate. Ah. Ah. No, merely with reference to a master plan. You can deprive a person of his right to use property. 300A. What does his constitutional right say? He has the right to use the property, right? You want to acquire it, do it. Pay, make payment of compensation. How can you prevent him from making use of his property? Which law prohibits? Which law prohibits that he can't use his property? Tell me. He must be regretting that why he has made the application. So by making the application, he is spending his life in court, right, in litigation. He should not have made an application at all. So therefore, you ensured that he spends his life in the High Court. So he will pass an order. How are you aggrieved? There is no direction against you, Mr. What is annexure B? Where is page? Annexure B page. No, Mr.
We have a quality where only land is converted prior to 79 are saved. And that is the nature of the.
No, we really don't understand. You require his land. Then, so what is your problem? Deputy Commissioner will decide. So if you have no objection, if Deputy Commissioner decides it independently, right? Why have you come here? No direction.
You could have informed the commissioner that my opinion is not required.
There's no direction to you. Direction to consider the request. Oh, you can't consider, right, request even. That is too much when the court asks you. How can the court ask me to consider the request of someone? Oh, that's it. No, you have to give no objection. What have you done? No. What happens to he is deprived of his property to make use? You are not acquiring his land. You don't need it. No, you don't need for airport. He is the owner of his land. He wants to use it for his own purpose. You don't even want that he should, I mean, what? Because merely because his land is near airport, so he will be what? Without compensation deprived of right to use property. Where from are you getting all this? Don't think I mean this is the law. What is it? What you were directed to consider, what have you considered? Nothing. The interim order was granted much later. This was after 3 years you were granted interim order. Till then, what did you do? Nothing. Why do you need NOC, Mr.? Which provision requires that NOC from? This, in fact, litigation is about nothing, right? But a massive ego of authority. He's telling us that nobody can ask me to consider a request. Is the submission? Why do you need? Which provision you need is the NOC of authority? He's happy, you don't ask him, you decide. Huh? Yes. They will not seek your opinion, Mr. Be happy. No, we are just trying to understand which provision Deputy Commissioner is required to obtain NOC. 95, you have made an application, right, for diversion. So he should decide. That's a statutory power. Why do you need the opinion of NOC of this authority? Which provision? Tell us. No, this is a new procedure, right? That if an application under section 95 is filed, you refer it to opinion of this thing for opinion of planning authority. Which provision? No provision. 395. That's why he is being dragged into court. He committed the mistake of making an application. He is suffering now since how many years? 2013, 11, 12 years, now 11 years. Which provision? Huh? Okay. You had moved an application under section 95. Yes, Mr.
Next J identical matter.
Yeah.
Identical matter.
endorsement.
Page 230.
Planning. of-
Page 233. Identical case, Mr. No, under which provision your opinion is, Mr. Section 95? That's what it is. That's what I mean. You have made a this thing, made him a football because he made an application. If the deputy commissioner sends you reject, then you are filing an appeal. Who are you? Under a scheme of 95, nothing. You take care of the airport, not of the this thing, conversion. Right? Which provision your opinion is required, Mr.? Oh, that's why you have filed an appeal. You should have written that you are the authority. Take care. That's the proper course. Unfortunate. This all litigation goes on here like pending since 10 years now. Nothing.
What is your stand?
Hey, Mr. Devi. This thing is, the question is whether a person can be deprived of his right to use the property. Huh? You will refer it to somebody. Huh? You should have decided it. He has a right to hold the property under Article 300A. That can be scuttled by referring it to planning authority. And your discretion will be affected by whatever planning authority says. What have you done? What happens to this, Mr.? Just see the frivolousness of the issue involved and the litigation. Just see the amount of public money and time which is being spent on this frivolous litigation. Because you don't perform, your officers do not perform the duties properly. Section 95, you have to decide, right? Which provision his opinion is necessary. No.
This case, there was a dedicated planning authority in and around the airport area and mostly of the country from that. But they had a okay government. So that the government was not supposed to issue conversion order. They not the area people. This was really not. They might have sought for opinion that is not despite this land being in a residential zone. The appeal coming is not actually involved. Who I will get it. I think not to be that is
doesn't come. It comes within this, but then there is no question of asking the no question from the planning. Separate authorities. One will be acting under section 95, another will be acting under section 14 of the town assembly.
Yes. This intra-court appeal is filed against an order dated 28th June 2014, passed by the learned single judge, by which a writ petition preferred by respondents 1 to 6 has been allowed. Paragraph. Facts giving rise to filing of this appeal briefly stated are that respondents 1 to 6 are the owners of land bearing survey number 50 situated at Singrahalli village, Singrahalli village, Devanhalli Taluk. Full stop. The respondents 1 to 6 filed an application before the Deputy Commissioner seeking conversion of the land. Full stop. The Deputy Commissioner thereupon by a communication sought the opinion of Bangalore International Airport Area Planning Authority, hereinafter referred to as the authority. The state government thereafter, by an order dated 22/8/2011, refused to issue NOC to the two respondents 1 to 6. Full stop. Paragraph. The aforesaid respondents filed a writ petition before the learned single judge. The learned single judge, by an order dated 28/6/2013, quashed the endorsement dated 22/8/2011 and has directed the authority to consider the request of respondents 1 to 6 as forwarded by Deputy Commissioner for no objection within the time frame of 6 weeks. To stop in the aforesaid factual background, this appeal has been filed by the authority. Paragraph. We have heard learned counsel for the parties at length. Full stop. The request for a paragraph, again paragraph. We have heard learned counsel for the parties at length. Paragraph. The request of a request made for conversion of the land under the provisions of Karnataka Land Revenue Act 1964 is dealt with by the Deputy Commissioner. Is dealt with by the Deputy Commissioner under Section 95 of the Act. Full stop. 95 of the Act, whereas an application seeking diversion is dealt with by the authority under the provisions of Section 14 of Karnataka Town and Country Planning Act. Full stop. In the instant case, respondents 1 to 6 had made an application under Section 95 of the Karnataka Land Revenue Act 1964. The aforesaid application dealt with by the Deputy Commissioner in accordance with law. However, instead of deciding the application, the same was forwarded to the authority. Paragraph. Therefore, in the facts and circumstances of the case, the order dated 28th June 2013 is modified by directing the Deputy Commissioner to deal with the application submitted by respondents 1 to 6 under Section 95 of the Karnataka Land Revenue Act 1964 in accordance with law expeditiously within a period of 1 month from the date of receipt of copy of the order. Full stop. In the result, that's all. In the result, line below, appeal is disposed. That decision be independent. Obviously, we have said in the that what both the powers are different, right? So right now, within a period of 1 month, right? You have written there. 1 month. Thereafter, needless to state that the aforesaid decision shall be taken by the Deputy Commissioner without being influenced by the opinion which has been given by the authority. What is it? Yes, mister. What is it about? What is the appeal about? Service matter. So what has happened? Learned single judges directed reinstatement. So you are agreed by that order. That's what we are asking. It's not a very difficult question, right? You are ready to argue the appeal. Let the other side come. Not been coming. You know that they won't come.
Last year, so.
Yeah.
Last year also.
Huh? Who has deposited? So, what is it? You have complied with the order or there is a stay? Then what is there to argue? Nothing. Oh, it appears that there is nothing in your appeal. That's why you are keen to argue. Huh? Nothing. Correct? Not like that. It appears like that.
But it is interim order granted.
The honorarium.
Reinstatement is stayed.
Technology is ready to argue.
The reinstatement order stayed.
See para 8. Left tribunal is considered. The writ petition is dismissed with cost of rupees 5,000. In paragraph 5. You are a private educational institution, right? You don't give an order of appointment. You are aware, right? You are what sort of, how do you indulge in exploitation of persons? Exhibit P12. Service confirmation 13. 16. Attendance register. English teacher. Nothing, Mr. How much amount have you paid? 16,000 rupees. Where is order dated 21st January 2010? Huh?
It's the only ground you have raised. That he was not your employee, that is the only ground. There is one judgment of this court against you. Have you brought it?
So they, for them to issue, they will never issue order. How do you explain the attendance of the respondent if he were not an employee? So where from, I mean, where from his signatures have this thing appeared in your attendance register if he was not your employee? Anybody can sign. Anybody can sign attendance register. No, you are saying no order of appointment. Then where, how she has signed? If she was not, if she was not your employee, how did she sign attendance register? That's the question which you have to answer. Herself. Oh, all your employees serve voluntary basis, right? Huh? Yes, Mr. That there is no attendance register. When she signed, if she 92 till 96 service confirmation certificate, exhibit P13, where from she has got? Exhibit P13 is the service confirmation certificate. That is also issued on his own. Is it not? Headmaster is not your employee. Then how he has issued? No, but how he has issued? Is it your case that his signatures do not appear in the certificate? Everybody attendance register also is not forced, right? Attendance register is forced. This headmaster is not the competent authority. And attendance certificate also is not correct. Right? So where from he is she? What is the explanation, Mr.? How headmaster has issued attendance certificate? So voluntarily, like without any salary, etc. So where is that? You must have taken an undertaking from her that she will not claim salary. Where is it? Huh? Time here. That's why this is trick is how can the explanation and there is a certificate issued by headmaster exhibit P30 results are all Voluntary basis. That's all. Duty to exploit employees. Right. Managing committee. That's the under an obligation to exploit the employees. But you don't, Mr. The fact remains that you are not disputing that he was your employee. Voluntary basis. What is the proof to prove? I mean, you have, if you are taking a plea, you have to prove that a voluntary basis, there is no material. Why she would serve on voluntary basis? Yes, without. We will seek a judgment at 4:45. Towards City. See, it's Paytm. After you have reinstated her, right? Huh? That they paid 60,000 rupees. We should try. Yes. Half-hearted. You told us you are ready. You are not arguing anything, looking at us. You told us that I want to argue, and you are not arguing anything, looking at us all the time. What did you argue? What have you argued so far? Nothing. Except telling us that she was voluntarily serving you. Nothing. You also know that you don't have a case. That's why you are saying in their absence also, I should be heard. Huh? What case? Do you argue, Mister? You are not arguing anything. Standing doesn't mean arguing a case. Huh? You told us, right, that you are ready and you want to argue. Did you not tell us? We are asking you, what have you argued so far? Tell us. Huh? There is no reason to be considered it to be untrue. You have not proved that it is forged. Huh? Admitting.
Was the headmaster examined on your behalf before the tribunal?
Saying that he did not issue the certificate. Then, nobody, you are also not competent authority to pay salary. Nobody. How she could have access to your attendance register, Mister? Voluntary basis. There is no material to show that she was serving on voluntary basis. It is all exploitation. So you don't issue an order of appointment to a person, that means he is not an employee.
For 10 years, she has worked. That you don't dispute. You don't dispute that she has worked. You say that she has worked voluntarily. Period is not disputed by you. Only you say is for all the 10 years she has voluntarily worked. In all 10 years there is attendance. Application for condoning the delay filed in the appeal. Anything else?
You told us that you wanted to argue. Okay, good. Order will be passed. Thank you. Don't make, Mr. this half-hearted sort of an attempt, right? You gave us an impression that you are ready, but in fact you are not ready. Turning pages here, standing, looking at us. This is not called argument. What did you tell us? Let them, they won't come. You hear me. This is what you told, right? This is what you have argued. Think, what have you argued? All right.
53. Sir, Karnataka Associates.
My lord, I appear for the respondent.
P. Jagdish. Government Educate.
My lord, respondent 1 to 2, my lord, I appear for.
'Let it be in the list. It will be called tomorrow. Let's see his 54. Yes. So whatever. Yes. So, Mr. Yes. 54. No, nothing told. Don't seek an adjournment. The bench will not change. We have, no, the last date you sought an adjournment. She is making a statement that she has not even been approached. Don't, Mr. We understand. No, you argue. Nothing. Otherwise, we will dismiss this appeal. Not on record. So we will dismiss it. No, you are not on record, nothing. You don't know anything about the case. No, there is no proposal, Mr. End of it. You start. Where is Mr. Ravi Shankar? We will not hear, I mean, in any of his cases in which he wants to seek stay from this court until let's see argue this. Not have any opinion. He has to be here, right? Mr. This case has a history. You don't know. Somebody else was appearing. You have been subsequently replaced. He argued the case for good 1 hour. Thereafter, he sought an adjournment. Thereafter, you have come. You are seeking. You have just a minute. You have sought adjournment. This case is being repeatedly. We haven't expressed any opinion. We only heard. But despite that, you feel that it will go against you. That tells us about your conduct as an advocate. How I mean, you. This is last date. You say reconciliation is possible 9/11. We told Mr. Ravi Shankar, you haven't approached her, and she is telling us that she has not been. Nobody has approached her. And you are telling there is an offer from her. Nobody has approached her. What are you talking about? No proposal has been made. See. Nothing. She's saying so. No, you get your senior. No, you start, Mr. No, nothing. Start reading judgment. He will come. No, nothing. Not. Start reading judgment. He will come. We are sure he will come. You don't have the file. This file. Have it. No. Then you start reading judgment. We are sure within 10 minutes, Mr. Ravi Shankar will be here. He will know. No, it doesn't come. You are, in any case, if you don't argue, we will dismiss it. It's not fair to the court, Mr. Nothing, nobody will come to your rescue. Read. No, nothing. Read. This is nothing, Mr. A decree of divorce has been granted merely because an advocate is involved. It doesn't mean that anything above law. He is also bound by law. His petition has been dismissed. What else? What is it? This thing great about this case? Dismissed with cost of 25,000 rupees. And it gives the graphic details what you have been doing. Read it. Read from paragraph 2. Three facts are as under. Read. Go ahead, go ahead. Let him relax for a while. You are reading the judgment. Go ahead. No, no, no. No, no, no. Go, go. Right? We have some intuition, right? No, no, go ahead, go ahead. Don't dilute. Continue tomorrow. List for further hearing tomorrow. Which case? All cases are being repeated, right? Even but 67. Since morning you are waiting for adjournment. Why? So you want to argue? 67. Why? His senior. You could have 67. Praise for adjournment. List. 1 minute. List day after 30th November. All the tomorrow it will be repeated, madam. Why? What's the urgency in seeking adjournment? Why? So you can argue two cases in a day. No, no law says that only one case and one argument. Which case? Which IA? Which IA? So this is writ of habeas corpus, right? So what? Let the petition be listed for consideration of IA number 1 of 22 on 30th.
67 on everybody. Sixty-seven are there. K11 and the last. 67.
Sir.